Introduction. Hackshaw vs. Shaw, 1984. High Court of Australia, 11 December 1984. Shaw was the owner of a farm. Petrol was stored for farming machinery. The petrol was being stolen at night, and Shaw decided to ambush the next thief of petrol. He therefore lay in wait near the petrol tank. Hackshaw was in a stolen motor vehicle with Cox. Cox drove into Shaw farm with the headlights turned off and started stealing petrol. Shaw fired two warning shots at the car and hit Hackshaw, who was in the front seat. It was expected that Shaw had not known that Hackshaw was in the car. Hackshaw sued Shaw, seeking compensation for her injuries. Issues: Shaw on a duty of care despite her being a trespasser on his hand. Shaw breached a duty of care to Hackshaw when he shot his rifle at the car. Hackshaw partly liable for her injury by trespassing on the land. Finding: Shaw owns a duty of care to Hackshaw to avoid injuring her by his rifle. He should have foreseen that it was likely that there could be a passenger in the car, and was negligent in firing the rifle at the car. Hackshaw's action accompanying cause had contributed to the injury as she had illegally entered Shaw's property. Dean J. said, "All that is necessary is to determine whether, in all the relevant circumstances, including the fact of the dependent occupation of premises and the manner of the plaintiff's entry upon them, defendant on a duty of care under the ordinary principle of negligence to the plaintiff. A prerequisite of any such duty is that there be the necessary degree of reasonable and proximity of relationship. The touchstone of its existence is that there be reasonable foreseeability of real risk of injury to the visitor or to the class of person to which the visitor is a member. The measures of the discharge is what a reasonable man would, in the circumstance, do upon the land. The mere relationship between occupier to take reasonable care to avoid the foreseeable risks of injury and to him or her when the visitor is on the land as trespasser. The mere relationship of occupier and trespasser has imposed upon the occupier will not satisfy the requirement of proximity or give rise to reasonable foreseeable risks or relevant degree of proximity. Something more will be required. The additional factor or combination of factors which may, as a factor of law, supply the requisite degree of proximity or give rise to a reasonable foreseeable risk. They will include either knowledge of the actual or likely presence of trespassers or reasonable foreseeability of real risks of such presence. In fact, it is now clear that an occupier of property can own a duty of care to a trespasser if it can be proven that it was foreseeable that trespasser could be injured by the negligent act of occupier. Contract managers should be aware that sometimes a duty of care can be on to people who commit illegal act of trespass. Conclusion: we would like to support the defendant Shaw in this case, as Hackshaw was in his property and indirectly stealing his asset, and Shaw was just saving his property from getting stolen. Also, Hackshaw cannot say that she didn't know anything about the intention of Cox. Although occupier of property can own a duty of care to trespasser, but he was saving his property from getting stolen. In our view, the one who owns the duty of care to Hackshaw was Cox, as he intentionally take her to that situation.